We now transition to the exceptions to the Hearsay rule, specifically those found under Federal Rule of Evidence 803. Recall that the general rule, codified in Rule 802, prohibits the admission of out-of-court statements offered to prove the truth of the matter asserted. However, the rules recognize that certain hearsay statements possess inherent trustworthiness, making them admissible even without the declarant testifying. This inherent reliability is the core rationale supporting all Rule 803 exceptions. This session focuses exclusively on two major exceptions rooted in routine, systematic record-keeping: the business records exception, found in Rule 803 subsection 6, and the public records exception, found in Rule 803 subsection 8. These exceptions allow us to admit documents created in the ordinary course of reliable operations, bypassing the need for live testimony regarding their creation. We will systematically analyze the specific requirements for admitting records under both of these crucial evidentiary provisions. Now that we have identified the business records and public records exceptions as our focus under Rule 803, we must establish the critical common ground shared by all Rule 803 exceptions. The most significant distinction lies in declarant availability. Unlike the exceptions found in Rule 804, which require the declarant to be unavailable to testify, the exceptions under Rule 803 apply regardless of whether the original speaker is available or not. This is because the inherent trustworthiness of these records is deemed so high that the need for live testimony is eliminated. For both business records and public records, this reliability stems directly from the manner of creation. Specifically, records created systematically, contemporaneously with the event, and under a recognized duty possess sufficient indicia of reliability to overcome the hearsay objection. These foundational concepts underpin why these documents are admitted. Building directly on that foundation of routine reliability, we now turn to the specific requirements for the business records exception, codified in Federal Rule of Evidence 803, subsection 6. For a record to qualify as a business record, 5 distinct elements must be satisfied. First, the record must have been made at or near the time of the event, either by someone with first-hand knowledge or from information transmitted by someone who had knowledge. Second, the record must be kept in the course of a regularly conducted business activity. Third, the creation and maintenance of that record must be a regular practice of that business activity. Fourth, all these preceding conditions must be established through the testimony of a custodian or another witness qualified to speak about the business's record-keeping practices. Finally, and crucially, the opposing party must not successfully demonstrate that the source of the information, the method of preparation, or the surrounding circumstances indicate a lack of trustworthiness. Meeting these 5 criteria unlocks admissibility. Now that we have established the foundation for admitting a document as a business record, we must address a critical nuance: the scope regarding opinions and diagnoses contained within those records. Generally, the exception covers factual observations and routine diagnostic conclusions, such as standard temperature readings or inventory counts. However, the trustworthiness requirement means that speculative or subjective opinions, like a supervisor's personal assessment of an employee's future performance, are usually excluded unless they are routine, objective conclusions inherent to the business process. Think of it this way: objective data is in, subjective judgment is often out. Furthermore, Federal Rule of Evidence 803 provides a related, though distinct, exception: the absence of a record, codified in 803 subsection 7. This allows evidence that a specific matter is not recorded, provided the proponent can show that the matter was one that would ordinarily be recorded by the business, and the proper foundation is laid. This proves a negative, relying on the same underlying reliability principle. We have just concluded our look at the nuances of business records, including the admissibility of opinions and the related exception for the absence of a record. Now, we pivot from the commercial sphere to the governmental one. While both business records and public records share the common foundation of routine record keeping, the source of their inherent trustworthiness differs significantly. Business records rely on the discipline of commerce. Public records, however, derive their reliability from the solemnity of official duties and the legal presumption that public officials act correctly and without bias in performing their mandated functions. This brings us to the Public Records and Reports exception, governed by Federal Rule of Evidence 803, subsection 8. This rule allows the admission of records generated by government entities under specific circumstances, which we will explore next. Federal Rule of Evidence 803, subsection 8, carves out three distinct, admissible categories for public records. First, Category A. Records or statements of a public office setting out its activities. Think of internal reports detailing the agency's operations or minutes from official meetings. Second, Category B covers a record of a matter observed while under a legal duty to report. This is crucial. The official making the record must have been legally obligated to observe and record that specific fact. However, we must immediately note a major caveat for Category B, which we will explore in depth next. This generally excludes observations made by police officers in criminal investigations. Third, Category C encompasses factual findings resulting from a legally authorized investigation. This includes conclusions reached by government bodies, such as findings from an Environmental Protection Agency audit or a Safety Board investigation. A unifying theme across all three is paramount. The record must have been made pursuant to a duty imposed by law or regulation, ensuring the systematic and reliable nature of the documentation. We now turn to the most critical limitation on the public records exception for uniform bar examination purposes. The exclusion found within subsections 8b and 8c. Remember, subsection B covers matters observed by officials, and subsection C covers factual findings from investigations. When these records stem from an investigation conducted by law enforcement in a criminal matter, they are generally inadmissible against the defendant. This exclusion exists to safeguard the defendant's Sixth Amendment right to confrontation. Investigative reports, especially those containing testimonial assertions, are viewed as substitutes for live testimony. Therefore, admitting them against the accused violates the confrontation clause unless the officer testifies. However, this severe restriction is narrowly tailored. This exclusion absolutely does not apply in civil cases. In civil litigation, investigative findings are frequently admitted because the confrontation clause is not implicated. Always remember this distinction. Criminal cases trigger the exclusion, civil cases do not. To conclude our discussion on these two powerful exceptions, let us synthesize the core differences. The business records exception, Rule 803(6), thrives on routine commercial reliability. Its foundation is the systematic, profit-driven nature of the record keeping, making it generally broad in scope regarding the subject matter it covers. In contrast, the public records exception, Rule 803(8), derives its trustworthiness from the solemnity of official governmental duties. However, this public nature comes with a significant caveat we just discussed: the severe limitation preventing the admission of law enforcement investigative findings against a criminal defendant. Remember, both exceptions serve the same overarching goal: admitting reliable documentary evidence without requiring the live testimony of the original maker. They bypass the hearsay objection because the circumstances of their creation guarantee sufficient trustworthiness. Keep this comparison sharp in your mind as you prepare for the examination.